Welcome back to the video lecture on East Asian state leadership in international law. This time, we are going to talk about the national practice of China for the interpretation and application of international law. The first, we are dealing with Chinese territorial and border disputes. As you know, China, with its vast territory, has been engaged in territorial and boundary disputes with nearly all its neighboring countries. The long-standing Russia-Ukraine conflicts, with its global repercussion, has further intensified discussions, which were previously only speculated upon hypothetically, and also on Chinese forced occupation of Taiwan following the recent armed conflict between Israel and Palestine. To best understand the generality and particularity of the Chinese territorial acquisition in the context of the territorial acquisition laws in international law, research on Chinese territorial and boundary disputes with their distinct factual backgrounds is a crucial preliminary undertaking. In other words, such analysis of Chinese territorial acquisition, the practice derived from its territorial dispute cases, enables the exploration of whether this practice develops from Eurocentric international law and its general theory of territorial acquisition laws. Let me touch upon the case of the Taiwan Strait. The legal status of Taiwan Strait are focal points in the ongoing rivalry between the United States and China become a subject of controversy in international law. Generally, a strait refers to a narrow natural passage connecting two large bodies of the water. The Taiwan Strait is a naturally formed passage connecting to East China Sea and the South China Sea and serves as a vital oceanic traffic route, not just for China and Taiwan only, but also for Korea and Japan to the Indian and Atlantic Oceans. With an average width of 180 kilometers, the strait accommodates the passage of 600 to 800 cargo ships and 900 and 1,200 aircraft on a daily basis. The strait, along with the Malacca Strait, is a strategic point that could threaten both China and the international community should regulations be imposed on the maritime routes. As a strategic military base and a hub for oceanic deployments to counter the United States, the significance of the Taiwan Strait for China will likely be magnified. The confrontation between the United States and China over the Taiwan Strait is acutely manifested from the diverging definitions of the legal status of straits. More specifically, it is polarity of the United States claim of the freedom of navigation versus Chinese claim of control of the passage and navigation as coastal nations. For the Commander's Handbook on the Law of the Naval Operations, the U.S. legally and largely distinguishes maritime spaces as a water subject to state sovereignty, for example, internal waters, territorial seas, and occupied waters, and international waters, for example, continuous zones, exclusive economic zone, and the high seas. Accordingly, the United States categorized the Taiwan Strait as international waters, whereby all countries have the freedom of navigation and overflights, much like the high seas. China, in turn, has perceived the U.S. stance as an attempt to mediate Taiwan issue as a threat to Chinese sovereignty. Notably, through a press conference on June 13, 2023, a spokesperson for Chinese Foreign Ministry, they explicitly opposed the U.S. designation of the Taiwan Strait as an international waterway. Based on the United Nations Convention on the Law of the Sea and domestic Chinese law, China contended that the waters of the Taiwan Strait extend from both shores toward middle of straits and are Chinese internal waters and territorial sea, continuous zone, and EEZ in that order. China further asserted sovereign right, and jurisdiction over the Taiwan Strait, all while emphasizing its respect for the lawful rights of other countries in relevant waters, effectively blocking U.S. access to the Taiwan Strait. Conversely, Taiwan, through the statement from its Ministry of Foreign Affairs, has maintained a position akin to that of the United States by categorizing Taiwan Strait as an international waterway and applying the principles of the freedom of the high seas to waters beyond Taiwan's territorial waters. Then, how should one interpret the U.S. claim regarding international waters in response to Chinese efforts to internalize the Taiwan Strait? In the event an armed conflict arises regarding Taiwan Strait, the freedom of navigation for third-party vessels in the Taiwan Strait should be maintained under international law, regardless of the peacetime or wartime. However, in time of the war, there exists interpretive disputes as to whether international permits a coastal state to close states comprised of the territorial waters and prohibit the passage of vessels from non-conflict third-party states. In conclusion, the United States-China confrontation over the international legal status of Taiwan Strait stems from the two countries' fundamental differences. Whereas China emphasized that the strait is a body of the water where coastal state sovereignty and registration must be applied, the U.S. advocates for freedom of navigation. The navigation regime and international strait regime are the foundation to the current stability of maritime order. Consequently, Chinese international legal basis for denying the navigation rights of other nations over the Taiwan Strait remains very unclear. Since 2012, the more issues that happen, they go beyond the Taiwan Strait issues. This is the South China Sea dispute. Chinese exercise of jurisdiction over the sporadic island has gradually increased as tensions between China and the Philippines have escalated due to territorial dispute over Scarborough Shoal in the South China Sea, as well as the conflict regarding fishing activities in the surrounding waters. Activities such as land reclamation and artificial land, the island construction, petroleum exploration, and fishing issues have also led to heightened the friction with the ASEAN countries, including Philippines and Vietnam. In response, the Philippines initiated arbitration against China in 2013. In 2016, the Permanent Court Arbitration issued a judgment which is widely considered to provide guidance for future dispute resolution by providing clarity of the legal and factual issues in the South China Sea. More specifically, the tribunal clarified that the Chinese claim of the historical rights within the 9-dash line did not comply with the UNCLOS, and that a country's right and obligation were recognized through the UNCLOS and existing international legal orders. Furthermore, the tribunal clarified the legal status of the Spratly Island. By categorizing the Ituaba, the largest feature of the island, as a rock rather than an island entitled to EEZ and continental shelf, the tribunal held that each feature of the Spratly Island was entitled to territorial seas. This simplified the maritime boundary disputes among coastal states and provided considerable clarity to the extent of state jurisdiction. Nevertheless, Chinese state practice continued to contradict the tribunal's ruling. Recently, Chinese Foreign Ministry asserted that a vessel from the Philippines, the Bureau of the Fisheries and Aquatic Resources, intrude into the waters near the Scarborough Shoal without Chinese permission and attempt to ram into the shore's lagoon. This is a lake formed by the cemetery, the formation that blocks the entrance from the sea. As a response, China claimed to have taken lawful measures to expel the Philippine vessel from its sovereign territory, which involve the isolation of the floating diverges. Based on the two cases which I mentioned here, then let me talk about the Chinese interpretation and application international law or more details. A study on Chinese diplomatic policy suggests that China has not always established traditional tribal relations with neighboring countries. Furthermore, Chinese diplomatic documents and record a history of relations regulated by a complex set of the rules and practices, including trilateral relations and tentative compromises. According to study, such complex rules and practices are based on interconnected concepts of legitimacy, equality, reciprocity, and mutual respect for territorial sovereignty. Recently, in the field of international ocean law, there is a discernible and trend toward differentiating Chinese interpretation and application of ocean law as the Chinese style of the ocean law. This essentially creates a separate normative framework with distinct Chinese characteristics that deviate from a universal force typically associated with the international law. This raised the question of whether it is possible for Chinese interpretation and application international law to descend the Chinese-centric norms toward the universal normativity. Thank you very much for your attention.